Good evening. My name is Joel Westfall, and it is my pleasure to serve as the Deputy Director of the Gerald R. Ford Presidential Library and Museum, and my honor to welcome you tonight for this evening's program, Past, Present, Future, the Twists and Turns of the Equal Rights Amendment and the Quest to Put Equality in the Constitution. Tonight's program is a collaboration between the Gerald R. Ford Presidential Library and Museum and the Gerald R. Ford Foundation, with additional resources from the National Archives Foundation through generous support of Maggie and Robert Bourgeardet. We are recording this event for replay on YouTube for your information. We'll be incorporating your questions throughout the program, so please use your chat feature throughout the program. Tonight, it is my pleasure to introduce Ann Compton, moderator for tonight's panel. Ms. Compton hardly needs an introduction. In 1974, she became the first woman assigned to cover the White House on network television. Her longevity and impact unparalleled. After retiring from daily coverage in 2014, Ms. Compton reignited her legendary career by returning to ABC to cover the 2016 political conventions, as well as accept a fellowship at Harvard Kennedy School of Government, focusing on media coverage of the 2016 election. She also holds a seat on the governing council of the Prentice Miller Center for Presidential Studies at the University of Virginia. Ms. Compton's career at ABC News spanned 7 presidents and 10 presidential campaigns. President Barack Obama announced her retirement when calling on her at West Wing news conference saying, "Ann Compton, everybody here knows, is not only the consummate professional, but is also just a pleasure to get to know." Ms. Compton was traveling with President George Bush on September 11th, 2001, and was the only broadcast reporter allowed to remain on Air Force One to report on behalf of all the press during the chaotic hours following the terrorist attack when the president was unable to return directly to Washington. For that coverage, which she considers the most significant story of her career, Ms. Compton received special recognition and awards bestowed on ABC's coverage, including an Emmy, a Peabody, a Silver Baton, and the DuPont Awards at Columbia University. Her colleagues elected Ms. Compton as president of the White House Correspondents Association for 2007 and 8. She was the chairman of Radio Television Correspondents Association on Capitol Hill in 87 and 88. The Commission on the Presidential Debates selected Ms. Compton to serve as a debate panelist in both 1988 and 1992. Additionally, she has been inducted into 6 Hall of Fames and received 5 honorary university degrees. Please join me in welcoming Ann to introduce tonight's panel.
Joel, thank you so very much. And thank you to all of those who have put together this wonderful evening. It was a half century ago this month that the Equal Rights Amendment to the US Constitution passed the House of Representatives by 354 votes to 24. The US Senate voted a year later 84 to 8. So why is it that this is still not ratified? Well, it is a fascinating real life story with twists and turns and cliffhanger moments for the last, not 50 years, but the last century. We have 2 rich resources tonight that are going to add to our conversation. From the renowned National Constitution Center in Philadelphia, Dr. Curry Sautner, using 21st century savvy, she pursues her focus on creativity and innovation to lead all of the exciting ways which the center reaches and teaches and celebrates what it very modestly calls the greatest vision of human freedom in history, the US Constitution. But that's not all. From the very front lines, we have Kimberly Peeler Allen. She's not just focused on women's political leadership. She's at the forefront of movements like the ERA Coalition. She's at the heart of all of it, at the Center for American Women in Politics at Rutgers and in New York State, where she's been right there working on the inside with names that you've heard in the news. Kimberly knows what's at stake with women's political power, and both of them tonight are going to look forward to taking your questions. Look for that Q&A function down at the bottom of your screen. Please, we look forward to seeing the questions you pose for our two panelists. And if you'll tell us who you are and where you are while you're watching, we would be grateful for that. So let us get right to some of the questions of the evening. And Curry, I'm going to start with you at the Constitution Center. It is not supposed to be easy to change the US Constitution. It's a sacred document. We say that our principles are enshrined in it. So frame for us, if you will, some of the twists and turns of the past that got us to the precipice where we are today. Please, Curry.
Well, thank you so much for having me. And it's so wonderful to be on this amazing panel with Kimberly. So the United States Constitution, 1787, the framers are in Philadelphia writing this document that enshrines our freedoms and has been added to 27 times over the years. But it's not just that it is a document that we believe so strongly with today, but it is a document that did two things. One, the founders were humble enough to say, maybe we didn't get it 100% right. Maybe this document needs to live a little bit longer and have an ability to change with the people and the people's needs. That's the amendment process. It's in Article 5 of the structural or original Constitution. And we're going to walk through kind of how this works, how it happens, so we can understand the ERA in context and say, where is the ERA in this process? And what are the conversations and questions we've had with it since 1923 till today? So the other reason why it's not easy to add an amendment to the Constitution is because the founders, although they may have been humble at times, not all the time, but at times, they also understood that you don't want this document and the structure of the Constitution and the structure of our government to change at a whim. And so if there's just a whim of the people, they don't want it to change every 5 minutes. So it is difficult. And there is a lot of work that goes through that process. So we can drop in a link to the interactive Constitution, but check out the amendment process in Article 5. And really quickly, what it does is first, it begins with a proposal. And so that proposal for the ERA came from Alice Paul and others in 1923. And it proposed the idea that there would be an amendment in the Constitution that said you could not be discriminated based on sex. Now, that proposal, like you just said, Anne, a great part of the method and the plan has to go approval from Congress. And that's 2/3 of the members of both sections of Congress. So 2/3 of the Senate and 2/3 of the House. As it goes from those two stages, it goes to the next stage. Now it goes to the states for ratification. And there's two ways to be ratified by the states. A proposed amendment must be ratified by 3/4 of the states, and it can either do that by states can ratify a vote in their state legislators, or it can be ratified for convention. Only one amendment has ever been ratified by a convention. Everything else went to the vote for the state legislators. So that is the process that the ERA is in right now. It's in that same state legislation process. And we're going to talk more and more about that tonight. If it gets to the next stage, it becomes law. So that's Article 5 of the Constitution. And when we think about the ERA and we dive into the ups and downs, we hear all these stories as the process come out. But one thing before we do that, I want to pull out, as we look at American history from 1787 till today, there are other amendments that play a part of this story. Right. Number one, the First Amendment. That the First Amendment was always there for all people in America to be able to have voice and agency in just telling their government what should be changed, what should be fixed, and what rights and privileges they should have. Part of that is speech. Part of that is petitioning Congress, but also part of that is assembly. And we see the women's rights movement use assembly over and over again to ensure that their voices are being heard, but also to get attention for their cause. And I wanted to just ding that bell a little because the First Amendment is a really important part of this story. The other part of the conversation will come around the 14th Amendment that was added in 1868. And it begins to put that promise of the Declaration that all men are created equal into the Constitution, and it does vow towards equality under the law. Now, people like Alice Paul and others said, you know what, we need to say not against sex. And this is how the story really begins and moves through the process. So lots of part of the Constitution come into play in this conversation. And our agency, the fact that the Constitution begins with three little words, we, the people. And that means it's our energy and our agency that goes into these changes of the Constitution in large and small ways. So we look at the whole document to understand women's and everyone's fight for equality.
Well, remember too, that in this case, last year in 2020, a 38th state finally ratified it. Why isn't the process already underway to nail it into the Constitution?
So let's talk. Would we like to jump here, or would you like to jump to Kimberly on this one?
Go ahead and you tell me on the technical, because I've got good questions for Kimberly too.
You got it. So technical side of it. So basically, in the easiest way to think about it, there's an expiration date that was written into the precursor of the proposed amendment. And that's the tricky part there. So you had the amendment was proposed in 1972. And very quickly, there is a movement towards moving that amendment to become ratified by the states. And then there's a little stall. You've got the stall, and then you've got another kind of push and kick in that begins with the states like Illinois, Nebraska, and then Virginia being that 38th. 38th should put it over that mark of how many states that it's needed. But the question is because the expiration date, which was advanced, able to be valid or is it invalid? And this is where the Department of Justice came in the last grouping and said, you know, we do not allow it at this point in time. There's questions about it going back to Congress, and can Congress change that expiration date? And then therefore the 38 states will go in. So the debate is open about this amendment being a legitimate amendment to be moved forward. What are the steps to make that happen? Or are there things that need to be moved around, or should we start from the beginning again? Lots of questions around that. And all sides are looking at that expiration date and looking at what can they do to either say that this is it or to move it forward. And that's the debate that is still going on today.
Well, and Kimberly, that leads me right to you. Why has it taken actually not even 50 years, but 100 years to move this forward? The social forces that have kept this locked up. Can you address that, Kimberly?
Of course. Oh, so sorry. I thought I had silenced my phone. You'd think after a year and a half, I'd have that down. The Equal Rights Amendment is a piece of legislation it's an amendment to try and remedy, the omission of women from the Constitution. As Curry just, very eloquently laid out the origins of the Constitution and how it has been amended so many times because our founding fathers recognized that, okay, maybe we won't have it right all of the time. And so to try and remedy this huge omission of sex equality, it also really moves on the change of the social fabric and the understanding of what people have said, oh, well, if we give equal rights to women, then who's going to take care of our children? There were ads in the 20s when it was first introduced, and those ads and political cartoons were rehashed in the 70s of children going hungry because their mothers were out marching for the ERA or out working because exactly working to maybe put food on the table. So there was that piece. Then the other part of it was also that so many of the laws prior to had been in protection of women, that women were seen as the weaker sex, seen as needing to have a male guardian, whether it's their father, their older brother, or their husband, to basically take control of their lives. And if we gave women equality, then, the argument was, oh, we're eroding the foundation of marriage. Women won't feel that they need to get married because they won't need that protection. We will be eroding our families if we have to make sure that we are paying women the same as men. Then what does that mean for our bottom line? What kind of changes do we have to institute when we have to make the playing field truly level? And I think there's just been a lot of discussion around that. And as the parties have evolved over time, it actually has always been a bipartisan issue from the very beginning, but we've seen proponents on both sides of the aisle. We have seen supporters on both sides of the aisle, and they raise similar arguments, and the arguments just kind of go back and forth depending on where the party structure is at the time. As we know, the Southern Compromise and how the Democratic and Republican ideologies more or less flipped, and we saw the view of women's rights also flip in that space as well. So I think it's been a lot of conversation about how do we address the changing norms, how do we address the changes in society, and ultimately, how do we disrupt a patriarchy that this country has been built on? So I think those are some of the real core issues as to why the ERA hasn't moved forward, because I think when you actually sit down and say, should women be treated the same? Should women have the same access? Very few people are going to say no to that. But when you put it in the context of constitutional equality, that this is something that cannot be eroded, it cannot be variable between states and municipalities and the federal government, that is when the things start to change in people's minds for those who are opposed to it, is saying, well, maybe this is going too far, and we need to think about what this means for our social fabric overall.
And Kimberly, the women's movement and the Equal Rights Amendment movement was not always united. I was surprised to learn that Eleanor Roosevelt was not on board. Is that right?
Yes, that is what I have read. It has, like I said, it really has gone back and forth around what the access would be, what is the equality standard? Are we giving up protection for our women? Do we need this protection for our women? What is the impact on our economy if this happens? What happens to our men? So all of these conversations, even people who have been supporters of women's rights, constitutional equality has been kind of that variable that goes back and forth as to whether or not people support.
Curry, maybe it's a moment we should actually remind people what the language is in this amendment. I've got it right in front of me, and I bet you do as well. What is the line? And this dates from 1923, correct?
Yes, it does. So do you want to read it out loud for everyone?
Do you have it right there?
I do. So if we look at the words, and Kimberly so perfectly laid that out for everybody, and the question is always, wait, why were women left out in the first place? And I think that's an unbelievably important thing to address up front, to talk about up front, and then to explain why in 1932, you have the major leaders like Alice Paul and Crystal Eastman really saying, this is what we want in there. So equality of rights under the law shall not be denied or abridged by the United States or by any state on account of sex. The Congress shall have the power to enforce by appropriate legislation the provisions of this article. Now, what you see there is you see echoings of the 13th Amendment, of the 14th Amendment, and of the 15th Amendment, saying that equality cannot be denied based on these reasons, and then adding to it. And by the way, Congress, you now have more power to do something about it through the law. That is what they wrote into this. And they're looking at the greats of like Bingham and saying, this is how we're moving this forward. And we're echoing the other parts of the Constitution that are pulling those ideals and values of the Declaration and trying to put it in the Constitution. So when we think and we go back to women being under the power and restriction of their male husbands, their male fathers, we also like, this is mind blowing to students that we talk to all the time. They're like, wait, what? And they're like, no, you had nothing. If you got married, everything you had, including you, were theirs. And there are some base laws to give you support and protections, but not many. And they're typically and mainly if you're a white woman of power that you have privilege to access those laws. So we have to be really clear that when we look at the power and the rights of women, we're looking at a diversity of women too, between socioeconomic class, between race, and we're looking at gender overall. And we even see infighting from women to women on these amendments when they all want to move it forward, but across these boundaries as well with the 19th Amendment, with the ERA amendment. And we look at the idea, and this is one of the biggest, we had this great lecture and podcast, and I'll send it out to everybody a few months ago on the ERA. And one of the key pieces that the leaders that believe that the ERA should move forward said is at times what we put in the Constitution isn't just something to change the laws, but it's our principles and the values that we stand behind. So they harkened back to Madison, which I absolutely loved, and said, Madison wrote the Bill of Rights. They really didn't go into play for 100 years. There wasn't many court cases around them, but they still put those values of freedom of speech, freedom of expression, the right to assembly. That's the First Amendment, will continue through to the 10th Amendment, but that's what they were calling for. So when you look at both sides, you hear that coming through for one side. And then the other side that I hear really strongly in those conversations is, isn't that the job of the 14th Amendment? And that's the discussion and debate that we should have as Americans today. Is the 14th Amendment enough, that it promises equality under the law? Or do we believe that we need to put the value that no right shall be denied based on sex into that Constitution?
Kimberly, you have a wonderful way of describing this. It puts a floor under what you can then build on. Can you explain that?
Absolutely. We look at the language that was introduced back in 1923, and there's a lot of discussion about in 2021, is this language still relevant? Should we be changing sex to gender? Can we update this in some way, shape, or form? And well, for one, if we were to update it, we would have to go through the entire process from the very beginning all over again. That would be a very time-consuming and expensive process when we are already on the cusp of codifying the ERA. But what I always say is, looking at many of the amendments to the Constitution, the amendment is the floor and not the ceiling. And we know that this is the first part of the conversation, and we can continue to build. I think about the 19th Amendment and also all of the amendments that came out of Reconstruction, that they have been fortified with things like the Civil Rights Act, the Voting Rights Act, because we knew that was the start, and there was so much more that needed to be done. But along with that, we also see that as things are done, they can be undone, as we have seen parts of the Voting Rights Act be struck down. So it is important that we have constitutional equality and not just rely on these bills that have come in through Congress and have been passed as laws, because we have seen time and time again that depending on the whims of the courts and the whims of our members of Congress, that parts of those bills can be either enhanced or they can be weakened by legislative and judicial decisions. So it is important that we start with that foundation of women's equality, because we currently don't have it. And then we can build forward to really make the amendment, make the laws supporting that are undergirded by the ERA, make them what we really want them to be, to really, as Kari said, really live our values and really be able to project our values beyond just the 28th Amendment to the Constitution.
I want to ask both of you. I know we are anxious to get to our audience questions, and I know there are many of them piling up. But please go down to the Q&A function on your screen, and please ask both of our guests these questions. But I want to ask each of you. I'm going to start with Kimberly. Give me some practical examples of what will happen if this does, or even more importantly, if this does not ever become part of the United States Constitution. Kimberly?
So what we have seen, because it is not in the Constitution currently, is a system of what I like to call duct tape and string, pulling together a variety of bills and laws that have tried to remedy the situation of not having equality. We're seeing the fights around pay equity. We're seeing the continued need to renew the Violence Against Women Act that comes up for renewal, every several years. We're seeing the discussion around pay equity, and we just passed Latina Pay Equity Day last week. And all of these things that we are fighting for, we would be able to, would not be issues if we had the Equal Rights Amendment. So there is this, the constant work. I mean, you have, for a democracy to truly function, there's always things that need to be done and need to be advocated for. But some of these issues, particularly around pay equality, paid family leave, looking at domestic violence, violence against women, equality for our transgender friends, and gender nonconforming friends. All of these things are bits and pieces that have been put together that would be remedied by the Equal Rights Amendment.
Okay. Can I ask you too, Curry, what would happen if this does not get ratified? Could Americans see tangible differences in their lives going forward?
And I think Kimberly answered that perfectly, because what you're seeing is this amazing work of people to ensure that you're not seeing a huge pushback or rollback, because it's lots of different people doing lots of different work across all different areas of the system. And so if we don't see it moving forward, you're going to have to see that much energy continue to go in, and the movement may not be as quick. So when you lay this out, and I go back to my earlier statement, when you lay this out, we can pull on the 14th Amendment for some of these pieces. We can pull on the 5th Amendment and due process for some of these pieces. But again, one of the best scholars I heard speak on this in the last year said, but shouldn't we put a principle in the Constitution that then supersedes as the supreme law of the land? And I think that's really kind of the energy that Kimberly was saying. Yes, we can do it, and this is what is possible. But at the same time, do we want to hold those constitutional values and principles in the document and put them in there? And then it's an overarching umbrella over all the states. So it is not just done on the district level, on the state level, and it really looks at equality not based on sex. So it's equal pay and so many aspects for women, but it's also paternity leave for men as well. And so many other people looking at this as something that needs to be removed. So again, I think we are an energetic, amazing democracy, and there are so much our people do to make this work. But the question is, where do we want to value it? And how do we as Americans believe that this should be in the Constitution? Through the laws bubbling up like very Brandeisian? Or do we want to say this is something we believe as a constitutional principle that needs out? And the question of how we get that done is even trickier, but also really interesting, that we talked about earlier.
This is fascinating. I'm just getting a question coming in for you, Curry, about the 14th Amendment. Let me ask all of our viewers, if you would like to submit a question, please do. We have another good 25 minutes going into this program, and I know our guests would have terrific answers for you. I must tell you, as you all are thinking about your questions, there are two moments in my career as an ABC News Network correspondent that have tremendous resonance for me right now. One is the first president I covered was Gerald R. Ford, and I traveled with Betty Ford across the country and back again as she went out and campaigned very hard for the Equal Rights Amendment. Her husband back in the Oval Office, not quite as vocal as she was. And you see here a picture in her White House bedroom office. She worked the phones. She had piles of paper. She was constantly pushing. On the left, I think that's one of her sons who had come in to check on her because she worked all the time. I'm not even sure she's out of her bathrobe there yet that morning. But look at the sign on her desk. The old phrase, don't tread on me, that kind of that fist in your face sentiment by the New Americans is turned into a banner, and it doesn't have a coiled snake at the bottom. It has pantaloons and the initials ERA, and that's the kind of thing Betty Ford just loved. The other thing that hits me, because before I started covering the Ford administration, I covered Virginia politics. I was, 22 years old, and the ERA had just passed the House and Senate, and the big hearing in the very conservative Virginia legislature was a circus. It was contentious. There were, I remember people spitting at the committee. I mean, this is the height of the anger and the disruption. And here last year, 2020, Virginia was state number 38 who finally came along and voted to ratify. So I just this moment feels very sensitive to me. Let me go to this question. Wait a minute, I have lost it. From viewer Emily Jacobs. Curry, will you expand on the type of precedence there is or is not for whether the 14th has protected women? You touched on this a moment ago, but it's a really good question.
It is. There's a couple fronts around this that we can look at the cases. We just, a few months ago, we had Akil Amar talking about this, and our teachers asked the same question because they wanted to know from him what he was saying. And he was pulling out this idea that the 14th Amendment is this equal protection clause. But what we can see also is that there's other values and other protections that haven't been covered by the 14th and haven't been utilized by court cases as a protection for those areas. So again, it's a modern debate, and both sides are very strong on should there be a standalone amendment or should there be the use of the 14th Amendment. And so you're going to have to make the decision for yourself at the end of this long answer. So Frontario decision is a big one, and this is the case that really looks at first laying out that there will be under the 14th Amendment, there will be a heightened scrutiny for gender. So when we're looking at cases and we're looking at how closely the court will look and examine a case where equal protection of the law or the 14th Amendment hasn't been applied, that it will be at a heightened level when it comes to a question around gender. So that's one example. Another one that I absolutely love with Alice Paul's story is we go back and we look closely at why did we want this amendment in the first place? It was for the rights of women to have the right to their property, to their selves, to their children, to the right to be able to move forward if they wanted to without a man connected to them. But also around that is labor. And Kimberly pointed this out so well. The labor to be able to go and support your family on top of all these other needs. So Alice Paul looked really quickly and said, it's 1943, they're looking at the ERA, but cases start to come down around being able to have protections for fair labor contracts. And it's all wrapped around fair labor contracts. And the first case that really comes out it's called the Lochner case. So Lochner looks at 14th, it says, no, you have to have a right around this. Now you have a little bit of a split in the party here. So Alice Paul says, this is great. This is exactly the angle we want to take at it. So when everybody thinks of Alice Paul as this amazing activist and this amazing person that can assemble groups and groups of people to get change, I also want everybody to recognize what an amazing constitutional lawyer she was too. Like really impressive how she's pulling these levers and moving forward. So she starts to move forward under this idea of a Lochner path. And it's Florence Kelley, who was also another social reformer, that kind of pushes back. And what Florence Kelley is worried about is she's worried about the fact that women don't have labor unions associated with them to support and protect them. And do they need more protection under the law? So you get this kind of split between the two and a rift in a few cases. And there are what's known after this as Brandeis briefs that come out of this. One of the big cases, Mueller v. Oregon, that you want to look at. And this pushes back this kind of right for women to have the right to contract in labor. But the case that I want to focus on that I absolutely love and don't think it's talked about enough is the Atkins versus Children's Hospital. Sorry, the date earlier was too late. This is 1923. This is a 5-4 decision, and it's smacking down the district or striking down the District of Columbia's minimum wage law for women. So again, when we look back 1923, we have different minimum wage laws for women and men. We're looking at not just the right of how many hours you can work, how few hours you can work, what conditions you can work in, what contracts you can sign, and what the fairness is of your wages. All these pieces are being looked into question. And that Mueller v. Oregon case pushes back Lochner and suppresses the 14th Amendment. And then we move forward with the Atkins versus Children's Hospital case that says, no, 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 you cannot do this to women. They are moving forward and they are doing the same work men are doing here. And they are in the same world that we are in, and they want the same rights. And this moves the women's movement forward for closer to moving towards how do we ask for fair contract of labor, but how do we ensure fair and equal pay? Something, again, was not done through this completely, but was the conversation began. So Lochner looks at 14, and the Atkins case looks at the Fifth Amendment in due process under the law. But even when you look at these big cases that move forward, that so many people utilize to say fair right to contract, you don't see a completely equal pay in women across the board, even though this was in 1923.
I have one coming in for you right here, Kimberly, a viewer named Tom in Seattle. Once the ERA, and this is a much more modern take on this, Tom says, once the ERA is hopefully ratified, would women's equality codified as law of the land give women complete control over their bodies and reproductive choices? Thanks for this important event, he says. So this gets to issues, and maybe we could also go into what it means for those who do not gender identify.
So that is a question that comes up quite often as we are talking to people about the ERA. What is the connection between the Equal Rights Amendment and abortion? And fact of the matter is, it is actually still open to interpretation whether or not the access to abortion is directly tied to the advancement of the Equal Rights Amendment. We have seen arguments from scholars and judges on both sides of the issue. But to be frank, I think there are many who believe or hope that it will, and many that will feel that it does not. And unfortunately, we won't necessarily know until it goes through, until it is codified and goes through the courts and goes through those legal challenges, whether or not it withstands.
And I'm going to get you to add to this something that you mentioned in the seminar with students today when they asked, what are the other practical effects, the practical changes that men and women would see if this goes through? What does it change about money and pay and all sorts of other things that would take effect once the economy would have to adjust to it?
Mhm. Absolutely. And being able to see, we are, as I mentioned earlier, we've just passed Latina Equal Pay Day. The Latinas in this country have had to work, almost a full year more than their white male counterparts to make the same wage. So there is that challenge, but we're also seeing the opportunity for women to really step forward and have the same opportunities to be able to, as we have been able to have these conversations, and there has been evolution in the thought around being able to negotiate contracts. My mother always tells us the story about when she first got out of college and got her first job, she wasn't able to get a credit card because she wasn't married. So we have come a long way, but there is still a tremendous opportunity to think about how actuary tables are configured differently between men and women. We're looking at as some of the states are beginning to prepare for the implication and the application of the Equal Rights Amendment, as we're coming up on the 2-year anniversary since its ratification in Virginia. I believe it's the state of Arizona went through all of their rules and regulations and came up with like a stack like this of just verbiage changes, because as they have been framing things, it has all been very gendered. And then thinking about if you change the gender, if you make the statement not gendered, what is the ripple effect? So actually going through and seeing, land use and job access and how we're taking care of our families and our communities, what this means for the care economy, the ripple effect is actually endless, because I think it is something that, as we have gone through and we've had this series of bills that have been pulled together by and held together by duct tape and string to try and make our country more equitable, we are not actually fully aware of all of the ways that we are inequitable, because we've been able to put all of these bandages around things to try and level that playing field. So as we get to the point where we are actually applying the Equal Rights Amendment to our lives, and through government actions, through pay, and then it's also the social construct of how, I think in many places, particularly in corporate America, there are places where the corporate America is ahead of the government in terms of, in some instances, ahead of the government in their ability to do their own audits around, are they really paying their employees the same regardless of their gender or gender expression? Are they really presenting the opportunities the way they should? Are they promoting? And that is a step forward, and they're putting together guidelines in their HR manuals and their HR practices to ensure that this happens. So there is a lot of moving parts that would definitely be strengthened by the Equal Rights Amendment, that, I think really the sky is the limit as to what the opportunities are.
Questions we don't even know that are questions yet. From Ypsilanti, Michigan, here is a question for Curry. Barbara Foster asks, since 38 states have now ratified, what's next? That's not an easy answer.
No, and again, we've been kind of addressing it as we go through, but you have a couple of options, and Kimberly, jump in on this one too, because I know you're an expert on this. So option one would be that the Department of Justice does another review and says, yes, we can move forward with this. This does, even though it was past the time, they were all still through, and we approved this can be moved forward. It's kind of one step. The last grouping of Department of Justice that did this said, no, you shouldn't move forward with it. They could apply and ask for another review. Number two, Congress could get together and say, multi-partisan initiative, we're going to move together and we're going to change that, time ratification clock. We're going to move it forward. We're going to reset the expiration date. Now we have 38 states. Questions around the 38 states would really come into effect around, there have been some states that have rescinded and pulled back. Do they want to jump back in? And can we really energize that? or are they able to be removed or not? So that's a little bit of an extra tricky wick there around it. The third thing that we could do, which is a little way more difficult, and Kimberly said this earlier, and I think she's absolutely right. We could start from the beginning. We could look at all the language again and move it forward. But I think there's a few options on the table. And really what I want to remind everybody is how this got kind of moving again in the first place. So when we think about, there's 35 states, and then it gets really quiet until like 2017, 2018, and then 2020. What's going on there? And what happens is it's kind of an odd backstory, and I'll tell it really quickly. But there's the 27th Amendment gets moved forward in 1992. And this is always one that makes you question the expiration date. So there's nowhere in Article 5 of the Constitution that says you have to put expiration dates on an amendment. It just became common practice because they wanted to kind of give it energy, move it along, and not have something sit for so long that the meaning of the words could change over time. And what does it mean and define to today? So one of the 27th Amendment is actually one of the oldest on the books. So it was one of the original 12 articles. Yeah, so it was one of the original 12 articles sent to the states for ratification. 2 were not ratified. And one of those was found from a student named Gregory Watson. He was a sophomore in college. It was actually spring break, which I always find so funny. He's like working on his paper over spring break. He's super excited about the ERA. And he's like, I'm going to do a paper on this. I'm going to write about an amendment that should get moved forward. In his research, he finds out that there is this Madison Amendment on the books. He pushes it forward. He writes the paper. He hands it in. He winds up getting a C. He's really upset about the C, so he questions his professor. The professor's like, it's a C paper, and hands it back. He gets annoyed and starts like a one-man campaign to get the 27th Amendment ratified, and does it.
Yeah,
years later.
College student.
Yes, college student, absolute college student with a C paper. So let's just remember that, students, if you get a C paper, you could still make an amendment change. And this is kind of where it goes back to the people. There were 3 women's studies students at a college that found this article a few years after. So it's like 1995. And they were like, they stopped and they paused. They're like, well, if he can do it for the Madison's Amendment, we're going to do it for the Women's Rights Amendment. And that's what kind of brings this a next initiative and push forward. And you've got this movement going forward in a bipartisan way. So again, how do we change the Constitution? We follow the process, but we also look for major moments in time where we can get a bipartisan initiative to generate energy to move a principle into the Constitution that we all believe in. And so the question for all of us, whatever way we choose to go in moving this forward, or questioning if there's a need for it, or the 14th Amendment, we have to think about the best possible way to do that, and how we as citizens have that power and the responsibility to check the Constitution and to ensure that it has the values that we believe in.
Well, this really energizes me, because exactly what you've talked about is leading to my last couple of questions for you, because we're almost out of time. And the Ford Foundation Museum Library wants you to know that the video that we are recording right now and will be posted on YouTube. You can go to the site of that, or I guess the Constitution Center might also have it. This video is absolutely, please do share it with friends, neighbors, college students on spring break, anybody else, to get the word out. And that brings me, before we have to hand this back over to our hosts, to ask each of you, and I'm going to start with Claire and then go to Kimberly. This is a teachable moment, and teaching is what the National Constitution Center does so brilliantly. And you are a PhD in education, and you have found very innovative ways of getting the essence, the modern essence of the Constitution through to students and to the rest of the public. Democracy is not a spectator sport. What could the members of the audience here tonight take with them to know how to or whether they should, or whether they really have a public responsibility to engage, talk to their neighbors, talk to their communities, and do something to make sure that this is their constitution too, and their voices count. Let me start, please, with Curry.
Sure. About 3 weeks ago, we had the president of the University of Pittsburgh do a class for us live from the center, Dr. Specker, and he talked about civic faith, but also civic agency. And the line that I loved from it more than any other class I think we've taught all year was, "You are the boss of your constitution, so start acting like a boss." And I absolutely loved it. And that begins, and you said it perfectly, Anne, it begins with listening and having conversations with each other about first what's in the Constitution, what it says, how it works, and then what do we believe needs to be shored up with another amendment, with a law to pass through Congress, or by the actions of the people themselves. So we always have to remember that this system of democracy that we're in, this republic that we live in, is an energetic republic that takes our energy, our knowledge, and our action. And that begins with reading the Constitution. It continues with having conversations, and the difficult ones, with your neighbors. But tonight, we always talk about homework. We're going to assign homework to all of us. Let's dig into the ERA a little bit more. Let's dig into the amendment process very much more. And then start looking at our own institutions, our own companies that we work for, or our own schools, and say, are they following the idea behind the ERA? Are they following the idea that the law is not based on sex and that you should have the right to it? So again, it begins with the Constitution, but it always sits in our lap, and we are the boss of that Constitution. So what are you going to do about it?
That's a wonderful, wonderful message to include. And I got to tell you, Kimberly, you've got kids. You know that we all may be, still working now, but that's the generation beyond the Alice Pauls and everyone else who are going to make a difference.
Mm-hmm. Absolutely. And that is a big part of why I do this work, looking at my son and my daughter and making sure that they are both on an even playing field, that my daughter has all of the advantages that my son does. And it is just so critically important that we engage. And we are, as Carrie said, we need to be a boss of the Constitution. I love that. Because, this is an issue that is very relevant. It is happening right now. Just this past Thursday, the House Oversight Committee had a hearing about lifting the timeline on the ERA. It has passed through the House of Representatives twice. It has not moved forward in the Senate. And there have been efforts to do that ever since we got the 38th state in Virginia almost 2 years ago, this coming January. And so, talk to your legislators, talk to your elected officials at all levels, because though we do not have the ERA at the federal level, there are several states that have instituted their own ERA into their constitution. Some are more expansive than the current language, some mirror that language, but there are several states that have equality on the books because they see that it has taken entirely too long for it to move on the federal level, so they're going to move at the state level. So I encourage everyone to check with their elected officials. Where do you stand on equality? Where do you stand on ratifying the Equal Rights Amendment and codifying it into the Constitution, so that we can actually have the laws and have an overall essence of who we are that is truly equal, so that we actually can all have the opportunity to live and thrive in this country.
Well, I must tell you, I don't have a son and daughter. I've got 3 sons and 1 daughter, but I now also have, since I retired from covering the White House for ABC News, I have 8 grandchildren. The oldest are all girls and very bossy. We're just now getting a few boys. And that is where you really begin to see how the next generation is going to live as a cooperative and work together on things on a different, hopefully a more level playing field that some of us, at least me, is older, significantly older than the two of you. And I want to thank both of our panelists for this really rich trove of information and thought, practical and historic thought, for sharing that with all of this. And I really want to thank as well the Gerald Ford Foundation, Library Museum, the great work that they do, the National Archives, which is the safekeeping for all of our history. And a special thanks to those of you who have put this together, our host tonight, including Claire Schubert, who was the good shepherd who brought us all here together tonight. Claire, thank you.
Well, the thanks goes to you, Anne, and of course to Curry and to Kimberly. Thank you so much for taking part in this important conversation with us tonight. And a big thank you to everyone in our virtual audience for taking part as well, and for your wonderful questions too. Programming like this is possible thanks to the Friends of Ford membership program. If you're interested in becoming a member with us and supporting our educational and civic initiatives, please visit the Gerald R. Ford Foundation website. Special thanks for this evening's program goes to the Gerald R. Ford Museum and Library and the National Archives Foundation, with the generous support of Maggie and Robert Beauregardie for co-sponsoring this event, as well as the student event held earlier this afternoon. And one last note before we leave you, the Gerald Ford Museum, Library, and Foundation are excited to welcome author Ian Toll to commemorate the 80th anniversary of Pearl Harbor on December 7th. This event will be virtual, so watch your email or visit the museum's website to reserve your space for this historic program. So once again, thank you for joining us this evening. A big thank you to Anne, to Curry, and to Kimberly. Thank you for watching and enjoy your evening.